Hello, my name is Oliver Howell, and today I'd like to talk about discovery challenges, particularly discovery abuse. You can find me on Twitter at MSUOliver. In 2014, finding the smoking gun of a case through discovery is extremely costly. Today we're going to focus on a couple of ways to reduce the cost of discovery that now represents about 80% of the cost in any litigation. First, developing a litigation budget. Second, cooperating with opposing counsel. And lastly, using technology in a way that doesn't rely too much on technology but has a human element. One of the main reasons why discovery is so expensive is because of electronically stored information. There's a huge amount of data that's exponentially growing, emails, tweets, etc. The more data that there is in a company, the more there is to search, and the cost of discovery gets higher. This leads to a temptation in some companies that don't necessarily understand predictive coding and technology to over-preserve in order to avoid spoliation issues, thus adding more data to an overwhelming pile. You have to weigh the costs of search with the value of information. One way that companies can reduce the amount of data is to have a document retention plan. They should delete trash as they go, don't just save everything. And as far as litigation goes, it's important to develop a flexible discovery budget early in litigation where you weigh the costs of the search with the value of the information. One of the purposes of discovery in general, in theory, is it allows the parties to reach settlement based on a more true and more complete information picture. It moves the discovering parties' expectations closer to a full information trial outcome. This results in increased chances of settlement, which is good for everyone. When both parties are optimistic, at least one of them is uninformed. Discovery allows the uninformed party to better assert its interests. When favorable evidence is disclosed, the opponent will revise as long as the disclosure is truthful and the information is verifiable, and settlement is more likely. One case where it isn't as likely is when a party discloses information only to show that their actions aren't as bad as an alternative. This has an unraveling effect, and in that case, settlement would be less likely. But the real problem is when discovery is used for purposes other than just sharing information. This is what we call discovery abuse. Discovery can be abusive when it's used for its impositional value rather than to seek out information. Big companies pick on little companies who can't afford to keep going in the litigation process. Overall, this detracts from the merits of the case. And unfortunately, in a lot of situations, judges can't really help because judges typically know less about the facts than the parties do. They're unable to process and properly assess the informational value of discovery requests. Because of all this, the discovery process is subject to abuse and can be used to extort an undeserved victory in litigation. So discovery abuse externalizes the costs of discovery. So it stems from the ability of the party to externalize discovery costs, just as a manufacturing plant has an incentive to pollute because they can externalize the cost of pollution on other members of society, such as the government. Law firms that use abusive discovery techniques don't have to pay the entire amount of their discovery requests. And when this occurs, the cost of the search is greater than the informational value of what they're seeking out. Whenever the costs exceed the benefit to the parties or potential benefit to the parties, the discovery is abusive. So some say that a solution to this is reform. Automatic cost reversal may decrease costs because the opportunity for externalization would be limited. Or by requiring the loser to pay the winner's legal fees, the attractiveness of unnecessary discovery requests would decrease. I suggest that cooperation reduce costs. If parties cooperate on setting limits for preservation, forms of production, privilege, and search methodologies like reasonable search terms, proper recall, and precision, the whole process costs much less. Technology obviously allows us to mine through all of the data cheaper and more efficiently than humans. Today, when lawyers use technology-assisted review, this is primarily in larger, more complex cases. One misconception is that the machine will do all the work on its own. Nate Silver coins the term garbage in, garbage out, GIGO. If you give a computer bad data or devise a foolish set of rules or instructions, it won't spit straw into gold, he says. The better the information and rules established by the human, the greater the capacity of the machine. So it's important to understand the technology. We like to say man plus machine equals relevance. Using the machine in predictive analytics, precision and recall abilities, that system tends to vastly outperform strictly human review. However, the effectiveness of that system requires the application of the right people with analytical skills and training who understand the technology. Many lawyers are unable to cope with ESI or TAR. So it's important to not let the technology get the best of you, especially with regards to e-discovery, because e-discovery vendors have an incentive to search as much information as possible and charge by the byte. So you must understand the technology, let the technology assist you, not replace you. The review using computers should be supervised technology assisted searches. So in conclusion, discovery should not be the fishing expedition that it is here in the United States. When this occurs, it detracts from the merits of the case. Ways to reduce discovery abuse are to form a litigation budget. Is it worth it? Is the informational value worth it? Cooperate with opposing counsel. And lastly, use technology in a meaningful and human-supervised way. Thank you for your time. Again, you can find me on Twitter at MSU Oliver, and have a good day.